Sanibona, ngaphambi singene kwivideo namuhla, ngithi angithathe lithuba ngibonge isupport nothando nesikhombise lona lingaphezu kokucabanga kwethu. Siyacela niqhubeke nisupporte njalo ngokubuka amavideo ethu, ungakhohlwa ukukhomenta, ushare, ulike. Siyafisa ukuzwa umbono wakho. Sicela ke singene kwivideo namuhla.
Advocate Ngcukaitobi.
Thank you, Madam Chair.
I apologize sincerely that we have taken a bit long. We cannot just blame Advocate Haley. We engaged him, and it took a little bit more time. We have read your papers.
Yes.
But you can have your 10 minutes.
Yes.
Uninterrupted. If a need arises, we'll ask questions.
Thank you, Madam Chair. There are 5 reasons why you should dismiss this application. Reason number 1 is that there is no factual basis for it. Reason number 2 is that there is no legal basis for it. Reason number 3 is that if you grant it, it will produce prejudicial consequences which cannot be remedied. Reason number 4 is that the application is based on hearsay which has not been corroborated. Reason number 5 is that the application is an abuse. If I can start with the first reason, which is that there is no factual basis for it. The application is full of speculation. It is not grounded on any facts. In fact, Madam Chair, the application is grounded on a falsehood. The falsehood is that the NPA has no rights to cross-examination, and only Mr. Ngcukaitobi has the right to cross-examination. The truth is that the NPA has the right to cross-examine. The truth is that the NPA has the right to bring any witness. The truth is that the NPA has the right to bring any documentation. The issue is that it must do it through the evidence leaders. It has no right to do it other than through the evidence leaders. And that is because the President has assigned the responsibility to draft the rules on the chairperson. And the chairperson has not only correctly, but rationally and reasonably elected that the exercise of cross-examination should be done through the evidence leaders. The NPA says that the evidence leaders are overwhelmed by the sheer volume of paper. We too are overwhelmed by the sheer volume of paper. But that does not mean we will violate our obligations to Mr. Ngcukaitobi to represent him properly. So if it means we must work over the weekends, we do that. If it means we must consult extra witnesses, we do that. Similarly, Madam Chair, you too are overwhelmed with paper and the volume of the documentation. But you too are also working tirelessly at night. You are not asking for someone else to perform your role as the panel. We're not asking for someone else to perform our role. I have a lot of respect for my colleagues who are leading the evidence, not only as colleagues. I believe they too are working very hard to make sure that the case is presented fairly and objectively. So the claim that they are overwhelmed is not supported by any evidence whatsoever. When you actually examine closely the founding affidavit, you find only one explanation behind this veil of being overwhelmed. It is that some information was given to the evidence leaders about Advocate Noko, and that information appears not to have been used by the evidence leaders. But that cannot be used as a basis to draw radical conclusions that the evidence leaders are overwhelmed by the sheer volume of paper. When you actually think further about Advocate Noko was called at the instance of the panel. So in that sense, she is a unique witness. She was called at the instance of the panel, not at our instance, not at the instance of the evidence leaders either. She became a panel witness. It is alleged that she was not questioned about her knowledge of poker. That may be so, but it is irrelevant because whether she is correct or incorrect about poker is irrelevant. She is a factual witness. What is important is that the panel itself must get poker correct, and we will argue that at a later stage. It's not necessary to resolve it now. If you look at the third basis for this claim, which is Advocate Haley has been involved in the matter for more than 6 years. I wish I were him, but I'm not. I've only been involved in the matter for the last 6 months. But I'm not making excuses. The same with my juniors. They have been involved in the matter for the last 6 months. One of my juniors only for the last 2 months. But we tolerate no excuses. The fact of the matter is we've accepted the brief and we must do our job. So we have had the same amount of time that everybody else other than Advocate Haley has been involved in. When you actually think deeper, Madam Chair, about what Advocate Haley is saying, he is basically saying he is the only one in this room who can run this case. Not you as the panel, not us, not the evidence leaders. He is the only one. Even his junior cannot do this case. It can only be done by Advocate Haley. Now, he says that in collaboration with Advocate Karen van Rensburg, because she is the deponent to the affidavit of the NPA. And when you think, where does he get this authority from? He says it's because he was at the State Capture Commission. He says it's because he has been prosecuting the individual prosecutors inside the NPA. We had not wanted to raise this, but for a long, long time, Mr. Chauke has told me that Mr. Haley is probably conflicted in this matter and should probably be recused. And we've refused to carry out that instruction. And today we have been told that, well, I have been in the case for the last 6 years. Often it happens that an advocate who has been involved in the case for a long period of time has a particular pattern of thought that they want to stick with, no matter the forum and no matter the countervailing evidence. So I wonder, without attributing anything, whether that is not in fact what has happened. Because the NPA is not asking for any other advocate in the whole of the Johannesburg bar. They're asking only for one person. Because on the logic of their argument, only one person can do this case. Now, you cannot make a ruling with such profound consequences for your inquiry for Mr. Chauke on the basis of the convenience of one man. And then when you look at, you ask Mr. Haley, one of the panelists asked, he says he is basing his claims on common human experience. Quite frankly, I have not seen any fault with the way the evidence leaders have run the case. Mr. Haley says it is not fair that a witness is led for 3 days and is cross-examined for half a day. Why not? Why not? There's nothing unfair in a witness being led for 3 days and cross-examined for half a day. And we must remember why we are here. It is simply because at a certain point in time, we reached the conclusion as Mr. Chauke's team that the inquiry must move forward. And if it means we must bring our witnesses before they close their case, so be it. But the inquiry must move forward. We are now being criticized for that decision. What should we have done? Walk away? Play obstructionism? We didn't have that option. We didn't think we had that option. Because at the end of the day, Mr. Chauke believes he's innocent. And he thinks he must call the witnesses to prove his innocence. And he thinks he must do so regardless of what is going on between the NPA and the evidence leaders. So what he is trying to do, in summary, is to try and assist not only the panel, but the president to show that Advocate Batoyi lied about him. That is what he is trying to do. So we say, in the first instance, there is just no legal base, no factual basis for the application. I want to come to the next point. We also say there is no legal basis for the application. Our learned friends have failed to identify a single legal provision that entitles them to run the case as if they were a parallel evidence leader. This is very telling when you listen to Mr. Haley. He says, by the very nature of the NPA, they have the right. But you cannot source a right from the very nature of the NPA. You have to source the right in law. So what do? They scramble around. Paja is inapplicable because that's the only source of the right to procedural fairness in this country. We've shown in our heads of argument that it is inapplicable. Then they look at another source, the rule of law, Section 1C of the Constitution. But it is such a nebulous reference that you can reject it without more. Then they say, look at the NPA Act. Section 12.6 doesn't give them the right to run a parallel prosecution. Then they complain that the president would not have enough evidence and therefore is likely to act irrationally if they do not have the right to play a parallel prosecution. But there's no basis for that because every piece of evidence they wish to present can be presented. They claim to have given the evidence leaders some information about Advocate Noko. Madam Chair, at Chambers, I said right as soon as this was mentioned, I said we will not tolerate any more ambushes like they were doing with Advocate Batohi. If they have information that is relevant to the witness, the information must be disclosed upfront, to us as well. Why? So that when we consult with the witness, we can put the adverse information to them, which is what we've tried to do with every witness. We find information that is good for the witness, we find information that is bad for the witness. In consultation, we confront the witness with both statements. Today, you will be hearing from Ms. Shamila Williams. There is some material there because she was from IPID, which is critical of her. We've put it to her and we've said, go to the panel, explain yourself. So none of the grounds that have been cited by the NPA as constituting a legal foundation for the case have any validity whatsoever. The fact that Advocate Batohi has been criticized...
Pardon, Counsel, I think your 10 minutes has lapsed almost.
Yes, I'm in your hands.
Yes, but let me just verify and clarify the point relating to the evidence the president having no evidence in relation to the rationality principle. How does it arise here?
It's irrelevant, Madam Chair. It doesn't arise at all. I mean, the best way to think about the argument is that if the NPA does not question witnesses, the president will not have enough information at the time that he makes a decision as to whether or not Advocate Chauke is fit or not fit to hold office. But that's 3 stages away from where we are today.
Had the president been given the information that was presented to this inquiry at the outset, would you say the president may probably not have established this inquiry? I mean, when you have all these dockets that are now presented before us, given the real issue here, I'm not prejudging the matter, but I'm simply saying, given the fact that the president was given the files that were given to us, which were legal opinions, including the legal opinion of Advocate Haley, in those files, none of the 23 dockets were included, not even a summary of those dockets.
Yes.
What do you make of that?
Well, certainly the president would have taken that into account, and I think it would have been a weighty consideration about whether there is a basis to establish an inquiry of this sort. And it's difficult to say he would not have established the inquiry because he was being urged upon to do so. But he certainly is a factor that would have been weighty in his consideration of the matter. There is also another...
In the letter by the president responding to Advocate Chauke's response, I don't have the letter right now, but the president suggested that it will be proper to, I'm paraphrasing, it will be proper there to investigate the allegations. Now, if all this information was presented to the president might have considered appointing other people to lead the evidence, most probably. Maybe even the NPA, maybe even Advocate Haley, we don't know.
Yes. Madam Chair, there is nothing wrong with our colleagues. You know, honestly, there is nothing wrong with Mr. Mutlamunyane. There's nothing wrong with Mr. Mutweni. It is an insult that we are sitting here debating whether 4 black lawyers are better than 2 lawyers that have been appointed by the NPA. It is a grave insult that we are still defending our reputation and our standing as black advocates in this country against people like Karen van Rensburg. How Advocate Motibi ended up supporting this application is beyond me. If the evidence leaders don't wish to defend themselves, we shall do it on their behalf.
You may deal with the next point you raised.
Thank you, Madam Chair. The third argument is that
the prejudice to
yes, there will be prejudicial consequences. Now, Madam Chair, we have completed, well, perhaps let me start with Advocate Batoyi. Advocate Batoyi elected to walk out and abscond. After absconding, she then made demands that she will only return after she has received legal advice. But that is her choice. We will deal with the consequences of that in closing argument. The 3 witnesses that have come afterwards, Advocate Mayema, Advocate Noko, and Mr. Mangena, have testified and gone. The prejudice is you cannot have a category of witnesses whose evidence has been presented according to one regime and a different category of witnesses whose evidence will be presented on a different regime. That creates an untenable inconsistency in the procedural framework of the inquiry. Number 2, Advocate Chauke cannot be subjected to 2 rounds of cross-examination. He will open himself to be cross-examined by Advocate Mahlomunyane, and if Advocate Mahlomunyane wishes his junior to cross-examine, he will open himself to that. What he will not tolerate is double cross-examination. No other witness who has come here has been subjected to double cross-examination. Every witness has been subjected to a single round of cross-examination. That cannot change in relation to Advocate Chauke. Number 3, the inevitable outcome of the NPA's application is to prolong these proceedings. Advocate Chauke is entitled to a speedy resolution of his disciplinary inquiry. If he is guilty, he must be found guilty and fired, and then he must decide what to do with his life thereafter. But if he is innocent, he needs to go back to work and resume his career. What is intolerable is to prolong a decision about his guilt or innocence. Unfortunately, it's inevitable that there will be additional time that has been spent if you granted the application by the NPA. On the other hand, if you say to the NPA, you know, Madam Chair, I think I was saying this to my junior, Mr. Ramukhal. When we began, you repeatedly used the phrase hand in glove, that the NPA and the evidence leaders should work like a hand and glove. Now, one of them didn't listen to that. And it's clear that it's the NPA that didn't listen to that.
No, the NPA conceded. It accepted. If you look at the transcript,
yes,
that they will work together with the evidence leaders
Yes. Thank you, Madam Chair.
in that fashion,
Thank you,
as we proposed to them.
Thank you, Madam Chair. They just need to be reminded today that they must continue working hand in glove. We just cannot tolerate the scenario in which the evidence leaders are constantly being undermined by Advocate van Rensburg. So we say with respect, there will be prejudicial consequences to Mr. Ngcukaitobi. There will also be prejudicial consequences to the panel itself, because you just cannot meet your deadline. We don't want a scenario in which Mr. Ngcukaitobi returns to work on a technicality because the time has ended. Because the cloud will continue hanging over his head that he was once accused and he was never exonerated. So we want him to be exonerated. So we want to finish the hearing within the time stipulated by the President. And then there is this.
Well, Advocate Haley raises the problems, yet the commencement of his argument, he refers to the problems. Two of those problems relates to the statutory provisions.
Yes.
What do you make of that?
Well, the statutory provisions is a legislative impediment. No one can do anything about it. The same as the maximum period of this inquiry. It's a presidential prerogative. And no one can do anything about that. The bottom line is that all of us must work within the constraints of the statute and the constraints of the presidential decision. But we've got to do our best. And then there is the point, which is the fourth point on the prejudice. The NPA cannot identify a single witness that it gave to Advocate Mohlamunyane, and Advocate Mohlamunyane said, no, I'm not calling that witness. They cannot identify one. They complain about Advocate Ngcukaitobi. Advocate Ngcukaitobi never refused to testify. She gave two options. One, I will come if I'm called by Advocate Ngcukaitobi. Two, I will come if I'm called by the panel. She came as called by the panel. The fourth point is that the application is based on hearsay. The application makes sweeping generalizations about what has happened in this inquiry. They come from a witness, Advocate van Rensburg, who came here twice, 2 times. I don't know how many days we've sat, but I wouldn't be surprised if we've sat for longer than 70 days.
A deponent.
Yes, the deponent, yes. Advocate van Rensburg is the deponent in the NPA's application. She has been here only twice. There is no confirmatory affidavit, even from Mr. Sebelemeza. I would have thought that Mr. Sebelemeza has not been around maybe only 5 times. But for the bulk of the time he has been here. He is not confirming what is being said there. And he is the attorney that is briefing all of us. Well, it's not briefing us, but he's paying us when he does. But the fact of the matter is that there is no confirmatory affidavit from anyone who has actually witnessed what has happened. I understand Mr. Haley cannot depose to the affidavit because of the constraints of having to argue the case, but surely the attorney can depose to an affidavit supporting it. What is intolerable is to have a witness who speculates about things that have happened in this inquiry when they've only been here twice. And you should therefore take it with a pinch of salt, what she says. Then the last point is that this application is actually an abuse. We start off with Advocate Batoyi just walking out of the inquiry and then coming on conditions. Having started the inquiry, there is a pattern of abusive behavior. Then we think about deeply, what are they saying about Advocate Ngcukaitobi? They say they want to attack her credibility because she had been suspended at the time. They say that she doesn't understand poker. What does that have to do with the fitness of Advocate Ngcukaitobi, which is the center of this inquiry? And then you have Advocate Motibi, who it is said, Madam Chair, I wish to quote what is being said in the founding affidavit. In paragraph 6 of the founding affidavit, Advocate Motibi was appointed as the NDPP with effect from 1 February 2026. In the ordinary course of events, he would depose to this affidavit. Advocate Motibi does not, however, have sufficient knowledge of the facts relevant to this matter. Advocate Motibi has been briefed on the matter, and meetings will continue to be arranged with him to appraise him of the developments in the matter to enable him to have a complete understanding of the matter. He is, however, persuaded that this application should be brought immediately. But they concede that he does not have knowledge of the case. But despite not having knowledge of the case, he has authorized the institution of this application. This is the height of irrational behavior. We complain about this in the answering affidavit. You know what they say in the replying affidavit? They say, no. The decision to bring this application was taken by Advocate Batohi. So where we've got Advocate Motibi, who is no more than a rubber stamp for decisions that have been taken by an NDPP with a personal gripe. Now, this is an example of the abuse that we are subjected to by the NPA. It is also abusive in another sense, Madam Chair. You have repeatedly warned us. You know, I say to my juniors all the time, just listen to the warnings of the panel and comply so that we can all work together. You've repeatedly warned us that we are running out of time. Today we have a witness waiting in East London who wants to testify. We have another witness we've arranged for Wednesday and another witness potentially for Friday. The knock-on effect of this side skirmish is that the two witnesses that are waiting may be knocked on for next week. Yet on Monday next week, we have Mr. Danikas, who's waiting for us in Greece. Why? Because we're trying to put as much evidence as we can collect before the panel so that, in our view, respectfully, you can exonerate Mr. Chauke. The abuse comes in the fact that it's eating upon valuable time of the inquiry, particularly bearing in mind that it has been brought too late. On the case of Ngcukaitobi, we've done half of the case. If you think of the witnesses we've called someone from the NPA, and we've called someone who was a forensic investigator. But today we're calling someone from IPIT, and we still have to call someone from DPCI to complete the picture, and then two factual witnesses to complete the picture. So 50% of the Ngcukaitobi case witnesses have been called. But the remaining 50% are going to be dealt with on different rules altogether. That too would be abusive. And that is why, Madam Chair, with the greatest of respect, we say the application is brought on a falsehood. It should not be tolerated. It's ultimately an insult to the capacity and the ability of the evidence leaders. It doesn't matter how much you can try and change the character of it and say it's because they're overwhelmed. We too are overwhelmed, but we're doing our job. So you have to accept the premise, the insulting premise, that 4 black advocates cannot handle this case. Surely in 2026, we should not be living through this. So we ask with respect, Madam Chair, that you should dismiss this application because it's a contemptuous application.
Before you proceed, and I'd like Advocate Haley to deal with that in reply. A suggestion is made that when the panel allowed Advocate Chauke to lead his witnesses, it did so at the disadvantage of the evidence leaders and the NPA. I'm paraphrasing what they are saying in their papers. And they seek to suggest that that in itself makes the process adversarial.
Madam Chair, you can only make that claim if you've not been sitting with us here. If you have been sitting with us, you would have known that right at the beginning of February, there was a problem. There was the problem that the evidence leaders couldn't secure their witnesses timeously. We could have tried to exploit that problem, but our view was not to exploit it, but to assist the process, to say our witnesses are ready, they should be called. That could not be construed to disadvantage the NPA or disadvantage the evidence leaders. In fact, Madam Chair, if you recall correctly, when we debated this issue at the morning meeting, Advocate Skosana supported it. He said, actually, that takes the pressure off us because you can run your case. We, in fact, drew up an agreement. Half of that agreement was struck out by the panel, which I'm still aggrieved by. But the fact of the matter is that it was an agreed decision. With the NPA being in the room, Advocate Haley was with us in the room when we agreed that the way forward will be this. We even had a clause that said, if by the time we finish, they have witnesses they want to call, they must apply to the panel and then they can call them. The panel scratched that out, which means they now have an automatic right to call the witnesses. But we would have lost by now, Madam Chair. We've spent the whole month doing crucial evidence. We would have lost the whole month without evidence because what they said that the next witness would be Major General Boysen, but he is only available at the end of February, and his statement will be available at the end of February. I don't want to speak about the fact that we have not received that statement even now, which would have meant that we have a whole month that's wasted. So to now claim afterwards that it has come at their prejudice ignores the facts, but quite frankly is opportunistic. And so we say you cannot base your decision on something that is not factual.
And in any event, in litigation, if I may use the example, if a party is not ready and the case is being dragged, the opponent can set the matter down.
Yes.
The defendant can proceed and set the matter down and proceed with the matter.
Yes, and ask for a dismissal.
And ask for a dismissal.
Which we haven't done.
In this event, in this case, the panel sought to facilitate finality so that once the evidence leading team is busy with their witnesses, then the proceeding must continue.
Yes.
Because time is very limited.
Yes.
If we are to wait for another, say, 2 months, where will that take us?
Yes.
We have only a very limited time here. And remember, it was proposed last year that this inquiry should start in January or February.
Yes.
I'm not even sure whether the parties were aware of the provisions of the NPA that limits our work within 12 months.
Madam Chair, thank you. Yes, the only thing I wanted to bring to your attention is there was a reference in the heads of argument of our learned friends to the comparable provisions of the Judicial Service Commission Act. So we've found now the latest ruling by the Judicial Tribunal in relation to whether the complainant, Ms. Mango, was entitled to cross-examine Judge Mbenenge as a complainant, and the ruling was given by Judge Ngwepe saying that she is not, and we just wanted to circulate. But it's not binding, it's just useful background information. So we'd just like to hand that up if the panel wishes to consider it, but it's not strictly speaking necessary.
For what it is worth?
Yes. The only point then is, Madam Chair, I have to leave and I cannot stay for the reply. I'm sorry to Mr. Haley. It's not out of disrespect, but Mr. Ramokhale will stay.
Yeah, please, just one question. Depending on your answer, it may be more questions. But then this question relates to the issue of the argument about hearsay from Advocate Karen van Rensburg. Now, if you look at paragraph 16 of the replying affidavit, in that paragraph, Karen, I beg your pardon, Advocate van Rensburg states that she has been following the proceedings and at times she would even engage with counsel remotely. What is your comment on that one?
No, Madam Chair, that may be so, but she was not involved in the conversations with the evidence leaders. So it simply confirms that it's hearsay, that it was conveyed to her by the person who was involved, but she was not there.
Okay, thank you. Thanks.
Advocate Ngcukaitobi, we are not going to level a blame to Advocate Haley because we asked him questions.
Yes.
Of course, even though his answers were long, we had to clarify a few things with him. And as a result, we have breached our own time frames, disadvantaging. You had made it clear that you're going to request to be excused because of your other engagement. And I'm sure Advocate Haley will not consider your being excused as a disrespect to him. So he signals not. So we will excuse you, and your junior will take that seat as Advocate Haley replies.
Thank you, Madam Chair.
Thank you.
And also tomorrow, I will still be at my tribunal engagement. I'll come back on Wednesday.
Your junior will be leading the witness as you indicated.
Yes, thank you, Madam Chair.
Yes, thank you. Thank you, Counsel. Advocate,
Thank you, Madam Chair.
your reply.
If I can deal with the 5 aspects that have been raised, but in the reverse order. The first is to deal with the issue of the abuse of this process. My learned friend refers in the first instance to the issue of Advocate Norco's credibility and the fact that we've identified that there's a challenge to her credibility. I've referred the panel to the authorities in the to the authorities which deal with the importance of cross-examination, and particularly where questions of credibility might arise. So an attack on the witness's credibility is a very important attack in terms of understanding whether the witness is ultimately to be believed in any inquisitorial inquiry. Then, insofar as the understanding of poker is concerned, obviously we've debated about how important it is to cross-examine different witnesses on the question of poker. Advocate Norco has testified at length. If her understanding of poker is irrelevant, then it does, of course, beg the question why so much time was spent by on behalf of Advocate Ngcukaitobi in leading her testimony on aspects which are now said to be irrelevant. Then, insofar as Advocate Mutibi's knowledge of the matter is concerned, the point is that it was not a decision taken by Advocate Batoy on her own. It was a decision that was taken by the EXCO, as we've indicated, to launch this application. That EXCO would of course have included Advocate Batoy, but it was a decision taken by that EXCO. It would be, with respect, irrational to think that when a new person comes into office, that the new person has to acquaint himself with everything relating to the decision that has been taken. What he's authorizing is an application being brought for the NPA to participate. The actual factual matrix is irrelevant. Directors of companies take decisions based upon information that they may have no knowledge of. All they need to know is that they need to protect the interests of the institution which they represent.
Yes, I understand that background, that Advocate Mutibi had just assumed office
Indeed.
And he was not familiar with the background to these matters. If the decision were to be challenged, whose decision would that be? If, for argument's sake, the decision taken was to be challenged, the rationality of the decision was to be challenged, whose decision will that be?
It depends on what, if we're talking now about the decision to institute these proceedings, is that the decision we're talking about? Well, let's assume that there is a basis for the purpose of this argument. That decision would be the decision of the Office of the National Director of Public Prosecutions. It happens to be occupied by a specific person.
Decision. Even if he's advised by EXCO, but the decision will ultimately be his decision. Am I correct?
The decision would be that of the Office of the National Director. The Act makes provision for the Office of the National Director of Public Prosecutions, of whom the NDPP is the head, with various Deputy National Directors of Public Prosecution.
Thank you.
Then, insofar as the fourth proposition under the heading of abuse is concerned, the warning to comply with the timeframes and the fact that we are eating up valuable time in this inquiry, that leads us back to the proposition that we've advanced before. What we are really concerned with is that a full case be presented. What Advocate Chauke is asking for, and what we're asking for in the context of that is that we be allowed to present additional information, additional evidence, and ask questions that have not been asked by the evidence leaders, that has not been presented by the evidence leaders. The panel will always have a right and indeed a duty to sift through everything that is presented in its obligation to control the proceedings, to ensure that evidence is not being led, that information is not being produced, and that questions are not being asked that are merely delaying the matter.
If at the end of the evidence of Advocate Chauke, the evidence leaders will proceed leading their evidence.
Yes.
And it is at that time when the NPA, when it will be open to the NPA to present to the evidence leaders whatever information that they may wish, or you as NPA may wish to present. Will that not be doable? And why, if not?
So, what we're asking for in the first place is a right in addition to that. We will present them with all information.
But why? Why?
Well, we've made our point already, Madam Chair. We've said...
If you are going to repeat what you said earlier, I just want you to understand that the door has not been closed. We are just facilitating finality. When Advocate Chauke's case is closed and the evidence leaders are now ready, if they will be ready with their witnesses, you will have an opportunity as NPA to bring forth the witnesses that you say are available. We don't even know who those witnesses are and what evidence they wish to tender. But as you discuss amongst yourselves, evidence leaders and the NPA team, you will then decide which witnesses you want to lead and what information you wish to present to the panel. Will that not be doable?
I'm just trying to understand what is being proposed to me. If the question being proposed is that if we've got witnesses that we wish to lead. Let's deal with witnesses, and I'll deal with the other stuff later. If we've got witnesses that we want to lead, and the evidence leaders have decided for whatever reason not to lead those evidence, what?
We are not there yet. You have indicated earlier that they have not decided otherwise. And in that event, we'll cross that bridge when we reach it. The point is, when Advocate Chauke's case is closed and the evidence leaders are ready with the witnesses, including your witnesses, I suppose, why can't we proceed with those witnesses, including your witnesses?
No, we're not saying that we can't. I think the purpose of today's application is simply that we should be allowed to lead evidence if they choose not to lead evidence. That's the purpose.
If they choose not to lead that.
Correct. Whether it be witnesses, whether it be evidence, whether it be a question that is being posed, that we wish to ask, but which they don't. And if I might just add.
But we don't know whether it will happen. So why do you have to give you a relief of something that has no basis, factual basis? Because if that happens, Council, that's why I say we'll cross that bridge when we reach it. If that happens, you have to bring it to our attention. There's no reason why you cannot be afforded an opportunity to lead witnesses or to bring information forth that may be relevant to this inquiry. If the evidence leaders decide not to present that information, I did not understand your application to be based on that if the evidence leaders in future decide not to tender the information that you present to them or the witnesses that you bring to their attention, then you seek this relief that you are seeking. I did not understand your case to be based on that, at least by reading of the founding papers.
So that is the basis of the application, Madam Chair, that it's an anticipatory application in the first instance, and to the extent that information, because one of the issues that has been raised, but importantly, at the time when the application was launched, at that point in time, we had only been dealing with one witness who had testified, Advocate Norco, come and gone. But those are not the only aspects of what we are raising. One of the things that we've pointed out in the papers was that when it comes to, for argument's sake, we must be allowed to raise in objections. We also have to be allowed to raise objections if there's a valid basis. There's at least two illustrations of that, but the one illustration was the objection raised by Advocate Mchweni against the leading of witnesses, Advocate Norco at the time, where not Advocate Norco, Advocate Maema at the time, where the concern that was raised was that Advocate Maema was simply been told this is the information.
Remember, you are replying.
I do, I understand that.
You have to confine yourself to a reply.
You've asked me a question, Madam Chair, and I'm responding to the question.
Yes, I think you've made your point on that. I've noted what you said. You can deal with the next aspect.
Then, with regard to the prejudice to Advocate Chauke, the truth is that we are all under severe time constraints over here, some of which has been imposed upon us simply by the legislation. That can't entitle a witness. If the evidence leaders were to take a view of the matter to lead all evidence in the way that that would cover also the ones that we wish to ask, then how would that prejudice be different from what we are proposing? We are proposing simply that all aspects need to be canvassed. What Advocate Chauke has in mind is that he only wants to be cross-examined by the evidence leaders, and him and his witness only be cross-examined by the evidence leaders, and that he and his witnesses not not be subjected to questioning on the full gamut of evidence. If there's a question that is posed by by myself or the team on behalf of the NPA, then it must be so that that the panel believes is objectionable in any way. Then it must be so that the panel must intervene and prevent the question from being asked, if it is so. But he's asking that those questions must in advance be, the opportunity to pose those questions must in advance be disallowed.
Sorry to interrupt. I
Not
don't
at all.
think Advocate Chauke's case is that he does not want to be cross-examined on the whole evidence that was led. What I understand Advocate Chauke's case is that he doesn't want to be subjected to cross-examination by two parties, which does not stop any questions that the NPA might have to be given to the evidence leaders to be posed to Advocate Chauke. I didn't get their case to say we want to be cross-examined on very limited issues.
Yes,
Thank you.
I accept that. I accept that that's what he's saying. I'm cutting through all of that. And I'm saying to you, if that is his proposition, I don't mind being asked these questions. I just mind it being asked by you, Advocate Haley, or by you as the NPA. Then the question is, wherein lies the prejudice? Because it's been contended that there's prejudice in that. How is that prejudicial to him? His contention is that he doesn't want to be asked questions by two different people, irrespective of whether those two different people who may ask those questions, together, when put together, they cover the full gamut. So what I'm saying is that shorn of all his arguments, it is so that what Advocate Chauke is proposing is that he in fact doesn't want to be cross-examined on the full gamut. That's my proposition.
What is your comment on the possible conflict if you were to cross-examine Advocate Chauke? Very briefly.
Pardon me, Madam Chair, the possible?
Possible conflict on your part.
What? I
If
don't
you
see any
were-
conflict at all.
If you were to cross-examine Advocate Chauke?
Well, it's never been raised with me. In fact, it was canvassed during, it was canvassed in chambers. There was never a suggestion that there was any conflict. If I understand,
You can just answer that there's no conflict. You don't have to believe
I'm
it.
saying there's no conflict. But to complete that, because it was something I was going to address, to complete that, the first thing that has been raised by our learned friends for Advocate Chauke is that although he had raised it, a decision had been taken that they were not going to pursue it. And it certainly hasn't been raised with me up until now. So you can't both advance the proposition, then at the same time stipulate that you're not advancing it. How does one respond to something like that? So we're not proposing, in a nutshell, that these proceedings should be prolonged in any way. We're proposing only that the proceedings should engage with the full factual gamut of information that is available. If it should so arise that we purport or we attempt to introduce evidence or to ask a question or to cross-examine on any issue that is not relevant or somehow objectionable, then of course that objection will be raised and the panel will deal with it at the time. Then,
Sorry, Advocate Haley, and I'm sorry to do this to you
Not at all.
repeatedly. On the issue of conflict, you've penned an opinion which was adverse to Advocate Chauke. Now, you cross-examining Advocate Chauke wouldn't be that. Remember, bias is perceived, whether it's there or not. But if the receiver of the treatment perceives bias, then it should be investigated. Wouldn't you cross-examining Advocate Chauke based, and in the background of you having penned an opinion that is adverse to him, be seen as you defending your own opinion that you have penned?
So I think we want us to distinguish, Madam Baloyi, Mary, between conflict of interest and perception of bias. The two are not necessarily the same, although they could dovetail. The conflict of interest arises from one's involvement or potential involvement where you're protecting where you've got an interest in one capacity with an interest in a different capacity. And in the present case, if there's a suggestion that there's a conflict of interest, it obviously ought to have been raised with me in the first instance. And in the second instance, then I would know what the factual basis is to it. But the perception that I might be biased, I'm not even sure how to respond to that. There isn't such an assertion at the moment, but I imagine that it might have the seeds of such an assertion may well be lingering there. But I'm not sure what to respond to something like that because I don't know what the factual basis is for it.
The basis could be that you have already expressed a view in your legal opinions that were presented to the President, which has brought us here. Will that not constitute a perception of bias?
Well, with respect, any prudent litigant would often request his or her counsel to express a view on the merits or the demerits of his case. If that is a basis to say that that particular counsel is then disqualified, with respect, that cannot be right, Madam Chair.
We are far beyond 15 minutes. Just wrap up, please.
Thank you, Madam Chair. Insofar as reliance has been placed upon the contention is that with reference to the cases that have been cited, the provisions of Section 33 and PAJA have been excluded from an organ of state. And reference is made to a long line of authorities on that proposition. So, can I ask that you consider the judgment that has been referred to by our learned friends in that regard, and I'm just trying to find it while I sit here, but the judgment that has been referred to, I think it's the Curlin judgment. One need only consider paragraph 2 of that Curlin judgment where the court says in explicit terms that it excludes the situation where an organ of state is itself the subject of an application or of administrative action. So in other words, it applies on the facts of that case where an application is brought by the organ of state who seeks to self-review, as it were. And the court makes the point that in those circumstances, you wouldn't be entitled to rely upon the provisions of the PAJA. There is, as far as I'm aware, there is authority that says very much of the same in the context of an application brought by an organ of state, where the organ of state is itself now the subject of administrative action being exercised by another organ of state. And it seems to confirm that within that space, the first organ of state wouldn't be entitled to rely upon the provisions of PAJA. But we must understand the source of PAJA. PAJA was intended to give rise to codify the provisions of Section 33(1). The original source of that was Section 33(1) of the Constitution. PAJA, as I understand those cases and as I understand the Curlin judgment, they concerned with the application of PAJA to organs of state. It doesn't inhibit or doesn't prevent an organ of state from coming in under a different provision, which would have been the provisions of Section 33(1). Even before the Constitution was enacted, organs of state had the right to, under the common law, to bring an application to review the decisions of other organs of state and to review the decisions, their own decisions. It did so under under the heading of the administrative justice, but that was prior to the Constitution. If Section 33(1) gives rise to that right, but PAJA doesn't extend it to organs of state, then we would submit that the right is to be located then in terms of Section 33(1).
Well, we will consider your
Indeed.
written submissions on whether PAJA applies or not.
Indeed, but my case is not limited to PAJA. I thought I'd made that quite clear.
Yes, your case is covered also in your written submissions, the rule of law principles, legitimate expectations, Audi, rules of natural justice, all those principles that you espouse in your written submissions.
Thank you, Madam
We
Chair.
will consider them.
I appreciate it.
And the case law, of course, that you referred us to, which actually made us to work until early morning.
I apologize profusely for that. There's just perhaps one other thing that the suggestion, if I can, just to the suggestion is that there's somehow an insult against 4 black advocates. There's no suggestion at all, none on the papers. That is a suggestion that Advocate Chauke has sought to make. We have not said that at all. And the suggestion
You didn't
that
want us to get in that debate, Council.
I also
because,
didn't want us to get into that debate.
Yes, you remember when we started, right at the outset, the communication that was presented to us in writing, where certain insinuations are made. I drew your attention to a very patronizing statement in one of the letters. And I didn't take kind to that personally. I thought that that was not in good taste. And I think we can leave it to rest, because we don't want to get into those arguments about black, white. But we should not create an impression when we write to one another or even to the panel that some of the advocates who have been appointed don't have what it takes. We should not create that impression.
Indeed, Madam
In
Chair.
any
But
way.
we didn't create that impression.
Yes, that's why I don't ask to go there, to
Thank you,
get
Madam
back to those letters. We discussed it in chambers with the parties, all of you. And we caution that we need to respect one another in what we write, in what we say to one another. So I propose that we don't go back and forth about it. It is not going to help us in deciding the very issues that have brought us here. But it is all the question of respecting one another as parties, as lawyers, as judicial officers, as the panel. We owe it to one another. So I suggest that we don't go there to argue that point. Is not going to help us to decide the issues. Any other aspect?